8 and there's 8 years. I think one can go in the back corner.
Hello and welcome everyone. We're here at Florida Closing and Escrow. We're the only title company located in Sunny Isles. We have a 5-star rating with the BBB. Also, John Iowanu, the managing attorney and owner, has been voted as top 50 real estate attorneys in America.
Wow.
And I want to thank everyone for joining us today in person and live. Also, just to let you know, we're mobile, multilingual, digital, wireless, remote, and we go the extra mile to help you with your success. So today, John will be speaking about owner and tenant issues. And if you have any questions, you could put them in the chat and we will answer them. So welcome everyone, and I also have great marketing tools for you, such as this. You could do live stream opens, tours. We also have targeted digital AI marketing. You could pick locations and we set up an event. Also, if you would like, for campaigns for you to brand yourself and for your listings. So please contact us as needed. I'm at 786-457-6832 and John at 954-821-4166. So without further ado, John will be speaking.
Hi, Cindy. Does Star want to say anything?
Star, my assistant, had to join us today.
I'm sure she'll say something later. Hi, guys. How's everyone doing? Hi, everyone here. Today we're talking about landlords and tenants, and we have a handout today. We're going to be going through that. Anyone in the internet world, if you need a handout, Cindy can send it to you. Okay. So we're going to be looking at where in the contract. We're going to be looking at the contract first. Where in the contract does it talk about landlords and tenants? It is actually on page 2, which is the first page of your handout, and it's under paragraph 6, 6B to be specific. And so what does it say? So if there is a tenant or someone who's staying in the property after closing, you as realtors, you need to check off 6B. And what does it say? Basically, it says check this box if the property is subject to leases or occupancy after closing. And the paragraph goes on to say, if property is subject to a lease or any occupancy agreements, including seasonal and short-term vacation rentals, after closing or is intended to be rented or occupied by third parties beyond closing, the facts and terms thereof shall be disclosed in writing by seller, so they need to send an email giving you guys an update of what's going on with the current tenant. And copies of the written leases shall be delivered to buyer, all within, this is the important part, 5 days after the effective date. So once we have a fully signed agreement or contract, the seller must give a copy of the lease to the buyer. Now, once the buyer receives that within 5 days, buyer gets to look at the lease, look at the terms, see how long the remaining lease is. The next sentence says, if buyer determines in buyer's sole discretion, so again, completely up to the buyer after he looks at the lease, that the lease or terms of occupancy are not acceptable to buyer, buyer may terminate this contract by delivering written notice to the seller within 5 days after receipt of the lease. So 5 days to receive the lease after effective date and 5 days to review it. If during those second 5 days buyer sees something that he doesn't like, buyer can terminate the contract and get their deposit back. Okay, that's the important part. Those are the time frames for leases. It goes on to say, estoppel letters and seller's affidavits shall be provided pursuant to standard D. We're going to see that in a second. Except for tenant estoppel letters shall not be required on seasonal or short-term vacation rentals. So If you have Airbnb or something for a week or 2 weeks coming after closing, estoppel letters are not required, but we still need to know about those rentals because the important part is what do we put on the HUD as a title company? What gets transferred? Is there prepaid rent that's been made? So that's the important part of this section. Advises the buyer what those rates are and also advises us as the title company what to put on the HUD. If, and finally this last sentence, if property is intended to be occupied by seller after closing, that's not considered tenant. That's not considered landlord-tenant issues. That's a post-closing occupancy by the seller. So that's a different form, and it's a different addendum. And the rider is you, post-closing occupancy by seller. So we understand that, right? So if a seller's staying there after closing, it's not a rental, it's a post-closing occupancy by seller. So next page of your handout is the standard D. This is the only other part of the contract where leases are discussed. Standard D says lease information, and here it talks about the estoppel letters. Seller shall, at least 10 days prior to the closing, Standard D, paragraph D, yeah, that's where the other part talks about leases. Seller shall, at least 10 days prior to closing, furnish to buyer estoppel letters from the tenants. So it's the seller's responsibility to contact the tenant and get an estoppel letter filled out. And that's going to specify the nature and duration of the occupancy, the rates, security deposits, and things like that. If seller is unable to obtain such estoppel letters, same information can be furnished by the seller to buyer within that time frame in the form of a seller's affidavit. So on rare occasions, some renters, they're just not going to be cooperative. They're saying, I'm not signing anything, I don't care, whatever. So in those circumstances, we can prepare an affidavit which says the seller's swearing to the facts of this is the lease, this is the term, this is the duration, and we can use that for closing. And the rest of this, seller, okay. So what does that estoppel letter look like? That's in the next handout. Page 3 is what tenant estoppel letters basically look like. Each title company has their own. This is ours. And basically gives the name of the tenant, the property address, and whether there's a written lease or not, and what's the occupancy terms. Is it month to month? When's the start of the lease? When's the end of the lease? This is important for the buyer. They want to know when the end of the lease is. How much is the rent? And the important part, security deposit and last month's rent. Why are those important? Because if the tenant thinks that they've given a $3,000 security deposit, but the landlord's saying, I'm only holding $2,000, we need to get on the same page there because at time of closing, everything transfers to the new buyer. So if the tenant thinks it's $3,000, and when the tenant leaves, the new buyer is holding $2,000, tenant wants $3,000, then there's an issue there. So we have to be on the same page with that. Last month's rent, is it given? Because all of this is prorated at time of closing. These monies are taken from the seller and given to the buyer to hold until the tenant leaves. Is there a pet deposit? Is there an association security deposit? That's also an issue. And who paid that? Sometimes the owner has to pay that, or sometimes the tenant has to pay that. So all of this needs to be determined before closing so there's no issues after closing. So they fill this out. If you are a listing agent, you can fill this out for the tenant. The tenant doesn't necessarily have to fill this out. But on the next page, the tenant needs to sign it. So you can fill it out, give it to the tenant, say, look this over, is everything okay? You must have the tenant sign it and date it. And they're going to confirm on the bottom of the page what the security deposit is, and if there's a last month's rent, and if they've given any other money, because the important part, as we said, is all of this money gets transferred to the buyer at time of closing. Okay, so those are the issues with regards to the contract. Now we get into actual leases, the next page, and we get a lot of questions about contracts to lease and lease agreements. Is a contract to lease an actual lease agreement, and should a lease be signed before occupancy? Does anyone know that answer? Is a contract to lease an actual lease?
No.
Correct. And should a lease be signed before occupancy? Very good, class. That is actually right above the heading of this next handout where it says contract to lease. Right up below it, this is not a lease. A lease should be signed before occupancy. So be very careful of that. I've seen some realtors think, even though it's a weird name, contract to lease. So I don't even know why they call it a contract, but it's really an offer to lease if you think of it that way. And I've just seen realtors say, okay, we have a lease, and they send me the contract to lease. And I said, where's the lease? And we don't have one. So
Sometimes you can sign a lease without the contract to lease, directly to the lease.
absolutely. And that's actually my recommendation. I don't really recommend these contracts to lease because you have to do a lease anyway. I recommend emails, phone calls, getting on the same page there, and then preparing a lease. Because the issue with this contract to lease is number 2. There's sometimes a deposit that is requested with the intention, it says number 2, with the intention of entering into a lease with landlord. Tenant has paid a certain amount of money, sometimes to the title company, and we're to hold it until a lease is actually signed. But here's the problem with this. Go to the next page, number 15, at the bottom of the next page. And this talks about failure to perform. It states, if tenant fails to perform any of the promises of this contract, the deposit paid by tenant may be retained by or for the account of the landlord as agreed upon liquidated damages. So let's say you prepare this contract to lease, get it signed, tenant puts a deposit down, tenant changes their mind, tenant wants their deposit back, tenant's not going to get it because this contract to lease allows for the landlord to keep that deposit. So if you're going to do this contract to lease, I recommend not putting a deposit, but if you have to put a deposit, make it as low as possible.
John?
Yes.
When there's a deposit, can the listing agent's broker hold that escrow
Yes.
deposit?
Mhm.
And if there's a dispute between the landlord and the tenant, because the tenant decided to cancel the lease, now the escrow holder has to keep that deposit until they both agree, right?
That's correct.
What the resolution to this dispute,
That's correct.
I cannot give it to anybody.
No. What happens with us when we hold escrow funds, it happens a lot. We'll get a demand from one party saying, they're in breach, give us the deposit. And then the other party will say, well, they're in breach, give us the deposit. So we have, anytime there's a discrepancy on who gets the deposit, we have to hold it in escrow, or we have to send it to the court to hold, and then they have to go to court to fight it out. The law says that as an escrow agent, we can only release funds between an agreement of the parties signed or court order.
Court order.
So that's the only time you can release.
Okay. And is there a period of time that an escrow holder can hold a deposit? 'Cause
We've
it's
held-
been
we've
like
held-
it's
yeah.
been like a month and a half and nobody's communicating, there's silence.
We're holding deposits for years now
Really?
because it's one of them's a small amount. It's $5,000, right? So in order to get that back, someone has to hire an attorney because you have to go to court or arbitration. So one side doesn't want to start it; they want the other side to start it to pay the filing fees and things like that.
Exactly.
And so it's just sitting there.
Sitting there, but I can't
So
touch it.
Here's my recommendation when that happens is maybe reach out to the other side. Hey, look, it's $5,000. It's not a lot. You don't want to hire attorneys. We don't want to hire attorneys. Attorneys are going to cost $10,000. So why don't we split it and just get it over with? So there's some
So
negotiation
as an
that can
escrow
be
holder, you
done.
can make that suggestion to
Yes,
both parties?
Mhm.
Okay.
but they both have to agree and they both have to sign a release and
But
cancellation.
you as an escrow agent, an attorney, escrow agent, you have certain amount of time to hold the escrow, otherwise you gotta give it to the, you can hold it forever, right? You got a certain time to hold it.
There's no time frame. No.
Time frame.
I can, it's under our discretion. It says, actually in the contract, it says under escrow agent's discretion, we can hold it as a courtesy because we're not sending it to the court, because once it goes to the court, now everyone has to go to
You can hold
court.
it for 5, 10 years.
Yes, correct. We can hold it indefinitely. Some escrow agents don't mind doing that, some don't want to deal with it, and some will send it to the registry of the court. It's
That's
called.
right, that's what I mean.
Okay,
Okay.
good question. Right?
Thank you.
Okay, moving on. So the next handout is the actual first page of a lease agreement for condos. House or home leases are different. This is from Form Simplicity. You guys can get it there. Realtors and agents cannot prepare lease agreements for commercial properties. That needs to be prepared by an attorney. And also leases for more than 1 year needs to also be prepared by an attorney, because this lease that you have in your handout that you get from Form Simplicity is for a term not to exceed 1 year. You cannot do 1 year and 1 month leases because they can be challenged and they can be deemed ineffective. So it has to be for 1 year or less. Okay, everyone get that? And you cannot, let me ask you this, can this lease be renewed by an automatic renewal for an extra year? Can you renew a 1 year lease with just an automatic renewal?
I believe you need to sign a release.
Very good. We're going to go to the next page, and that's under XXI 21. Renewal/extensions. The lease can be renewed or extended only by a written agreement signed by both landlord and tenant, but in no event may the total lease term exceed 1 year. A new lease is required for each year. So this is very important. If it's a 1 month lease or 2 month lease, those can be extended up to 1 year. But once you get to 1 year, you need a new lease agreement. Basically, you need another one of these leases, okay? That's another very important point, because that came up in an issue. There was a lease. It was for a year, and then the tenant and landlord just allowed it to keep going. But technically, there was no lease at that point. The tenant thought that it was a lease for another year, but no, it's just extended month to month. So be aware that extensions for these can only be up to 1 year.
For a very common practice, I don't know how you handle it, when the lease expire, the tenant says, okay, listen, can you put me on a month to month until I decide what to do? You do month to month, are you allowed to?
That can be done, yes. But then you run into issues with month to month, and that's a very good point, and that's a very good transition into our next topic, which is going to be the Bill of Rights, which if you're on a month-to-month tenancy, there are notice requirements that are extended past the normal term. So let's go to the Bill of Rights in your handout. Not the next page, we'll jump back to that one in a second, but since we're on to that one, yeah, that one right there. The Miami-Dade Community Action and Human Services Department, Office of Housing and Advocacy. This is for Miami-Dade. This is the Notice of Tenant Rights. This must be included with all leases as of last year, 2022. This is a requirement for Miami-Dade County that with leases, this Bill of Rights for tenants must be attached to the lease and also signed by the tenants. And we look to the bottom of the page, which is now the notice requirements. And this goes to month-to-month tenancies. And to terminate a month-to-month tenancy, the Miami-Dade requires 60 days notice.
Notice, written notice.
So if you think it's a month-to-month, it's really now, if they're on a month-to-month, now they're given 33 months to leave because they have their current month and then additional 60 days notice. Also, for rent increases on month-to-month tenancies, you have to give 60 days notice. And also change of ownerships, you have to give notice to the tenant. So although I don't mind month-to-month tenancies, I prefer another agreement written up. Maybe make it 3 months and 6 months, but allow the tenant to cancel early if required without penalty. So at least you have a time frame, and you won't go over these requirement notices, and it might be a little bit easier than just saying, yeah, you can stay and just pay, because now you get into the requirement notices.
So one more question, John, regarding a very hot topic, it's on the news all over, especially in Florida. It's about the amount allowed to increase your rent. So people are saying, listen, now I'm gonna pay 20% more, I mean, what is this? And it's happening in Miami, so what's the legal procedure for amount of rent increase for tenants?
And how much notice?
So very good. So let's go back to the bottom of that Bill of Tenant Rights. Under notice requirements, number 1A is the month-to-month termination of tenancy. You have to give 60 days. Section B says rent increase. And it says your landlord must provide a minimum 60 days fair notice in writing if your landlord intends to increase your rent by more than 5%, either at the end of a lease or for specific term or duration of tenancy without specific duration. So if it's a month-to-month lease, so after the current lease has expired, if they're on a month-to-month, you have to give them 60 days notice if you're going to increase it more than 5%. You can, there's no law that says you can increase it whatever you want, 100%, 200%, but this allows the tenant to either agree to it or gives them time to find another place. It was 30 days, but they thought now in this market it's hard to find rentals. They're giving them an extra 30 days, so it's a 60 days.
Because some states are regulated, but
rental requirements in California, also New York, they're really strict on their tenancy laws. But Florida right now, we're good to go. You can increase.
People paying $1,000 now, the new rent is $2,000. It's all over the news.
Yeah.
Especially in Miami, downtown.
But here's the thing, if it's a regular 1-year lease, at the end of the lease, you can say to the tenant, you can stay another year, but your rent is going to be $2,000. You can do that. There's no 6-day requirement on a regular written 1-year lease or 6-month lease. It's just on these month-to-month tenancies you have to give notice. But at the end of a lease, you can say, okay, your rent now is going to be $2,000, and that's allowed. You don't need the 60-day requirement notice. Okay?
And I don't know if you addressed this, but what if there is an issue and eviction needs to be initiated? Any tips you want to give on that?
Evictions, this is a court state, let's say. So landlords have to hire attorneys and they have to go to court to evict tenants. I don't recommend hiring an attorney for that, believe it or not, because attorneys can charge a lot of money. There's actually eviction companies out there.
And we have, if you need.
Which we actually use.
Yeah.
If someone asks us if we need to evict someone. There's companies out there that do it for a really cheap amount of money, $500, $750, up to just maybe
I work for
$1,000.
$200 actually.
Yeah.
Or if an attorney is needed, then of course there's a higher fee. But you could contact me if you need the information.
And they'll do everything from the notice, the 3-day notice, all the way taking it to court and getting the judge's order. So eviction companies are the best way to do that instead of hiring attorneys. Sorry, attorneys. Let's back up one more to the early termination addendum in the lease. Right before the Bill of Rights, this is on page 7 of 18 of the lease. We get questions about early terminations and liquidated damages. If you check the first box, so we're all in the early termination.
This one, early termination?
Yes.
The first box.
First box means that if there is a default, let's say they signed a 1-year lease and they want to leave after 6 months, the tenant will owe the landlord 2 months' rent, and then the tenant can get out and everyone can go their separate ways. If the second box is checked, that basically means if they want to leave after 6 months, that they would owe the remaining 6 months. Early termination, no, you found it. So that's the difference between the two. First box is just 2 months that they owe for damages, the tenant if they want to leave early. The second box is they owe the remaining unpaid lease agreements, payments. Okay? Everyone
When it
understand?
said 6 months, but it says 6 months.
Well, it doesn't. So it says, the second part, I do not agree to liquidated damages or an early termination fee, and I acknowledge that the landlord may seek damages as provided by law. So damages provided by law is the full amount of the lease. If you enter into a 1-year lease with a landlord, you owe the landlord 1 year's worth of rent. So if you leave after 1 month, you owe them 11 months. If you leave after 6 months, you owe them 6. If you leave after 8, you owe them 2. So the landlord is entitled to the full amount of the 1-year lease. That's what that means.
Plus the deposit, I suppose.
No, the deposit actually is for damages. So that's separate than liquidated damages. So basically, the landlord's entitled to 12 months' rent. The landlord will technically give that security deposit back to the tenant if there's no damage.
Okay.
So the security deposit is a little bit separate than liquidated damages. Okay, and then finally, there is the notice of Bill of Rights for Broward. So Miami-Dade has their Bill of Rights for tenants, and the last page of your handout is the notice requirement for Broward. Make sure these are signed by both the landlord and tenant along with the lease agreement. All right, thanks everyone. I'll turn it back over to Cindy.
Okay, I just want to say thank you, everyone who joined us today, live and in person. And again, Florida Closing and Escrow, #1 title company in South Florida, the only title company in Sunny Isles, is here to increase your success. So please contact us when we can help you from contract to closing. Thank you for joining us today.
Thank you.